Salam and good day to you, Prof. My name is Sham, and together we're part of group number 1. And today we'll be exploring defamation in Malaysia involving celebrities. Without further ado, let's hear what Shakespeare has got to say about good name. Not that you have not heard it before, but yeah, for the sake of it.
Ladies and gentlemen, for one night only, would you please welcome to the stage Mr. William Shakespeare.
My name is Shakespeare William. I own the feather quill. I am the writer most familiar to you.
Good name in man and woman, dear my lord, is the immediate jewel of their souls. Who steals my purse steals trash. 'Tis something, nothing, 'twas mine, 'tis his, and has been slave to thousands. But he that filches from me my good name robs me of that which not enriches him and makes me poor indeed.
And she's here.
These words by Shakespeare echo across centuries, and nowhere are they more prevalent than in today's world of viral headlines and social media outrage. In Malaysia, as in many societies, the right to reputation is protected by the tort of defamation. In this documentary, we will look into how Malaysian courts deal with defamation cases, especially those involving celebrities. These days, it's very easy for someone's reputation to be damaged just through a single post or comment online. Social media and online platforms has given everyone, whether they are informed or not, a way to speak to the public. What they say can spread very quickly, even globally, and this puts celebrities at serious risk because their lives are always under the spotlight. We want to explore how the law protects the dignity and reputation of public figures in such cases, while also making sure that freedom of speech and the role of the media are not ignored.
Hi guys, I'm Muin. So before we move further to discuss our selected cases regarding defamation, let us see some of the viral headlines in social media where a person's good name can actually be destroyed in seconds by defamation.
Seorang peminat yang juga pengguna laman sosial Instagram memberitahu Mahkamah Tinggi Kuala Lumpur pada Isnin siaran langsung oleh 5 sekawan pada Julai 2021 hanya berkisar mengenai kelakuan buruk penyanyi dan pelakon Siti Nurdiana alias serta memanggil penyanyi rap Caprice dan wanita Indonesia dikenali sebagai Mondi Tattoo bagi membantu siasatan. Laporan dibuat pendakwah terkenal Abid Liu. Timbalan Ketua Polis Selangor Dr. S. Sakila Devi berkata pihaknya sudah menerima arahan bagi menyiasat kes itu. Fashion Ballet and Tart Group founder Datin Bini Sofina Yusuf has sued a netizen for defamation over comments on the government's financial relief for the B40 and M40 groups affected by the COVID-19 pandemic. The 33-year-old fashion icon filed the suit through law firm versus Fong Ching Leong and Co. on June 15. She named Ayah Najwa Hassan Muhyiddin, aged 28, as a sole defendant.
In Malaysia, defamation is a tort, a civil wrong that protects a person's reputation from attacks. It can happen through spoken words known as slander or through written or published statements known as libel. Our legal system recognizes that while freedom of speech is a fundamental right, it is not absolute. There's a line between expressing an opinion and destroying someone's good name. In this documentary, we will explore how Malaysian courts handle defamation cases, especially when they involve celebrities, the media, and the fast-moving world of social media. We will ask, How does the law strike a balance between protecting reputation and allowing freedom of expression? And are our existing laws enough to deal with the realities of the digital age?
Meanwhile,
Now, let's discuss our first case, the case of Jason Jonathan Lowe.
Our first case is a landmark judgment delivered in 2024. Jason Jonathan Lowe and Star Media Group Berhad and others. Jason Lowe, a prominent media personality, sued the Star for publishing 2 articles and a Facebook post linking him to child molestation and drug abuse. Though he wasn't named, the descriptions former CEO, local musician, father of 3 were enough for the public to correctly identify him. The court found the publications to be defamatory. The defendants tried to rely on 2 main defenses: justification, claiming what they published was true, and qualified privilege, arguing it was in the public interest. However, the court ruled both defenses failed. The journalists did not adequately verify the allegations. The repetition of unproven police reports without independent corroboration violated responsible journalism standards. The court awarded Jonathan Lowe 200,000 ringgit, noting the deep personal and professional harm. The case reinforced the repetition rule. You cannot escape liability by merely quoting someone else's accusations. Next, we will be exploring the case of Azwan Ali and Melody TV3, and my colleague will be doing that.
Ke Singapore, satu dunia tahu kau boleh follow IG kau, jangan edit sebab aku nak promote tambah followers. @Diva Azwana Bas 2019, di mana aku pergi sana, wahai Cik Adit, aku nak menggeletis cur. Jadi bila aku bercuti, aku cur, tiba-tiba dia call ni. Aku panggil dia hantu gaya. So pergi show dia. Hello, aku tak pergi show post macam tetamu konon VIP, tapi dijemput untuk melantak je. So I was the one siap buat dia punya FB live, siap pergi kat satu hotel sehari sebelum, dia siap merayu lagi suruh attend dia punya show. So kita ni terfikir kononnya 20 tahun kenal dia. Kita tak cakap soal bayaran ni, was not mentioned, tapi dia ada tanya kalau betul-betul show Diva A berapa. I told him $3,000. Muka dia terus berubah. Dia kata, mahal.
Stop it. Get some help.
In the year of 2000, Azwan Ali sued TV3's show Melody. He claimed a joke made him appear hysterical over Ziana Zain's marriage. The court found it was harmless jest in light entertainment setting and dismissed the case. In contrast, our second case involves satire and celebrity culture. In Muhammad Azwan Ali and System Television Berhad, Azwan Ali sued TV3's entertainment show Melody for mocking him, implying he cried over singer Ziana Zain's wedding. He argued that this made him look hysterical and humiliated, but the court disagreed. The judge found that the statement was made in jest, in a light entertainment context. The word menangis simply meant crying, and not in a defamatory sense. It was not an attack on his moral or professional character. Public personalities, the court held, must accept public scrutiny. If one enjoys fame, one must also endure criticism. The court dismissed the case, stating that the words were not defamatory in their natural meaning. Next, we'll see what it's like in the UK and also defamation according to Islam.
meanwhile,
Now, moving along to the next segment, that is comparison between the UK law and also the Malaysian law. Well, it goes without saying that the Malaysian defamation law is largely inherited from the English common law, while UK as a nation has moved forward to keep up with the changing time. Unfortunately, in Malaysia, we're still stuck with the ancient common law. So in the UK, they've introduced Defamation Act 2013. It was a major reform. So one of the first major things that they've introduced is raising the threshold for bringing a claim. Defamation Act 2013 required the claimant to prove that the statement caused or is likely to cause serious harm to the reputation. For companies, the harm must be serious financial loss. And the change was designed to prevent trial of vexatious lawsuits and strike a better balance between protecting reputation and ensuring freedom of expression, and at the same time not clogging up the court system. Now, another key reform in the UK was the statutory defense of publication on a matter of public interest. And for the better or worse, is the protection, the statutory defense is now codified into Section 4 with the aim, with the maqasid, to protect responsible journalism, even when the published statement turns out to be false, as long as the publisher reasonably believes that publishing it was in the public interest. We don't have equivalent codified defense. Instead, defendant must rely on common law defenses such as qualified privilege or fair comment, which are often interpreted narrowly inconsistently. So these differences suggest that Malaysia could benefit from legislative reform. The time is now. 50 years ago, most of the defamation are through the traditional print media like the newspapers. But in the advent of technology where everyone is given a megaphone through their social media account, the reform for Defamation Act in Malaysia is timely. We could codify a lot of things that wasn't very clear from the very beginning in terms of defenses, in terms of the threshold, and we think now is a good time to do it. Next, let's bring together what we've learned so far about defamation law in Malaysia and, of course, cases involving celebrities. So basically, we've examined two recent cases. Not very recent, Jason Jonathan Low versus Star Media Group Berhad, and Azwan Haji Ali versus Miasat Broadcast Network versus TV3. Azwan Haji Ali versus TV3. And the outcomes couldn't be more different. So in Jason Low's case, the media published serious allegations of criminal conduct. These weren't merely opinions or jokes. They were claims of facts, highly damaging, made without proper verification, and the court found that such reckless reporting crossed the legal line, so he won. By contrast, Azwan Ali actually brought a suit over a satirical portrayal of him, that he cried because Ziana Zain got married, and he wasn't too happy about it. But the court saw it differently, though. Azwan was a public figure who had, by his own conduct, invited scrutiny, and the court ruled that it's all part and parcel of life being a celebrity. So what exactly separates the two outcomes? Context and intent. Defamation isn't just about someone who feels offended. The real question is whether a reasonable person will see it as lowering the reputation in the eyes of society. And this comparison also sharpens the reform debate. We still operate in a system where the defamation is presumed harmful, but Jason's case showed that the potential danger of unchecked media power, while Azwan's case warned against over-policing expression, especially in satire production. So if Malaysia were to adopt reforms similar to the UK, such as a serious harm threshold, statutory public interest defense, we might better filter out unmeritorious claims, in the word of Lord Bingham in Arthur versus British Gas, quote unquote, while protecting legitimate reputational interests. In a legal landscape shaped by both imported doctrine and local nuance, it's time that we ask, should our defamation law evolve to reflect the digital era and the growing importance of expressive freedom?
So, whether you are a celebrity, or a CEO, or an ordinary citizen, your good name is not just a label, it's the jewel of your soul. And as Shakespeare said, he who robs us of that good name beggars poor indeed.